Good morning. My name is Kevin Layde. I'm one of the partners at Layde and Parra, immigration law firm here in Milwaukee, Wisconsin. I'm recording this video because on Friday, May 22nd, heading into the holiday weekend, United States Citizenship and Immigration Services released probably the single largest policy change to green card applications in the 10 years that I've been an attorney. Essentially, USCIS has indicated that now they're strongly opposing or strongly disfavoring what's called an adjustment of status, which is a way for an immigrant to apply for a green card while they're here in the United States. So basically, when someone wants to apply for a green card here in this country, typically they need two things. One is they need to have entered the country legally with like a visa or what's called sometimes a parole entry. And they'll also need a petition filed for them. So it's usually having a member of your family file something to request that you receive lawful status here. And so this has been kind of a major bedrock part of our immigration system for the last 50 years or more. Generally speaking, if somebody chooses to adjust status here, even if they came in with a visa, many years ago, as long as they came in lawfully, they would apply once they have somebody who can file this petition for them. And we do many of these cases every year, as do the vast majority of immigration law firms. It's one of the best and fastest ways for people to get status here. It's a great way to keep families together. And now USCIS has indicated that they no longer wish to allow most people to be able to do this. They're stating that they wish to push individuals outside of the United States to return to their home country to get a visa there, and then only at that point return lawfully to the United States as permanent residents. Which is really just a completely different way to think about the whole immigration process, and it's going to impact possibly hundreds of thousands of individuals every year. And so, I think it's really important to be aware of this change and to understand what it means for any process that you're considering doing. So a couple points. First, it's very likely that this is not going to be the final rule or the final policy because it's such a major change. Immigration sort of just released it, sending out a letter on a Friday before a holiday weekend. I think this type of a change typically is something that should be done by Congress or through a larger rulemaking process. So it's very likely that this will get scaled back or struck down or something by the courts at some point. But for right now, it is the actual law, and it does impact cases that have already been filed as much as cases that might be filed in the future. Individuals, I have clients who have interviews this week, and we're talking about how to prepare for it just this very week, which is unfortunate because there's not a lot of advance notice for people. I think the other thing to keep in mind is that while it states that it's preferred that individuals process visas in their home country, it does not mean that you cannot adjust status. Essentially, the government has indicated that they're going to be looking closely in some new kind of questions about the reason why the individual is present in the United States, why they entered, why they didn't leave, why it would not be appropriate for them to have to depart the country. So things like, family ties to the United States, having children here, medical hardship to family, problems in your home country, different things like that can all come into play. And that's kind of how we're preparing our clients to be ready for this. Additionally, I think they're going to be looking closely at what's called discretion, which means sort of good conduct or good character or positive factors. So things like educational achievements or work history or some of the same stuff, taking care of family members here or being able to possibly speak English or have job prospects. All those things will weigh in your favor and potentially could still help you get this adjustment of status. So I guess the idea is, what should people do at this point, right? If they're considering filing a case, is this a good time to file, given these changes? And while this is a brand new policy, I certainly think that at this point, with the way the government is moving on things, I think it's very likely that there's more changes to come in the future. And so my perspective is that if people have the ability to move forward with the case and if they can get assessed and they can feel comfortable that they do have some strong arguments to overcome this policy change, and also knowing that this might not be the law forever, I think it does make sense on a case-by-case basis to move ahead with these types of applications because who knows what other types of changes are going to be coming during the rest of the Trump administration. I think other things to keep in mind is like, what do you do if you have a case that's pending already? So I think, if you're not working with an attorney, I think it's absolutely imperative that you try to speak with an attorney as quickly as possible now because there's going to be a lot of new things thrown your way. And I think you're really going to want to have some representation in your corner. I also think that if your case is filed, I think you need to see it through. I think you need to work to try to prepare yourself as best you can. And more information will be coming out in the coming days, weeks, and months about this policy, I'm sure. And so I think the best thing to do is to try to make a consultation with an attorney and speak to someone about it, because I still think there's a lot of opportunities for success. I think this is an attempt to try to get individuals to not be able to move forward or to be too scared to move forward with these cases. But I think the law is on the applicant's side, and I think if you can be brave and you can push on this, I still think there's a lot of good outcomes that can come from it. There are other possibilities. If a case is denied, there's appeals, there's federal court litigation. And here at Layde and Parra, we're happy to help figure out the best path forward for you for these adjustments. But just be aware there will be an additional scrutiny and additional changes that need to be looked at for these cases. And we're happy to help. So please give us a call at area code 414-488-1200 or come visit us here in West Allis in Wisconsin. And we'd be more than happy to talk with you and see what we can do to help your case. Thank you very much.